Irretrievable breakdown can be grounds for divorce. That is the big story at this hour. Hello and welcome to Newsroom Newsbreak. I'm Sarah Jacob. You're with us on NDTV. Let's bring you up to date with the top story right now. And it has emerged out of the Supreme Court this afternoon. A constitution bench of the Supreme Court today ruled that the court can dissolve a marriage in the case of an irretrievable breakdown by dispensing or doing away with the need of that waiting period, a 6-month waiting period which was required under marital law. So the big story, the Supreme Court today held that it can dissolve marriages now on the grounds of irretrievable breakdown of marriage. For that, it would invoke powers under Article 142. It has also said that the mandatory waiting period of 6 months for divorce through mutual consent can be done away with, but this is subject to conditions. So what are these conditions? We'll try and find out for you. It said, the court said that they've laid down factors which can determine when there will be an irretrievable breakdown of marriage. This is the hearing in front of a constitution bench. It comprises of the judges you can see on your screen: Justices Sanjay Kishan Kaul, Sanjeev Khanna, A.S. Oka, Vikram Nath, and J.K. Maheshwari. And of course, questions now will be, what are the broad parameters for the exercise of power under Article 142 of the Constitution to dissolve a marriage between consenting parties without referring the parties to family court, where you'll have to wait out that mandatory period, which is prescribed under Section 13B of the Hindu Marriage Act. Sunil Prabhu has the story from the Supreme Court today.
Trying to, see whether there is a possible of rehabilitation will continue. But having said that, what they are saying is when all options have been done, then the Supreme Court can do away with that mandatory 6-month period that is required. So it's in that context that they have very carefully worded and said that the irretrievable grounds for revocation of a marriage can be the Supreme Court, because it's the court of equity, can decide where matters have been settled, where there is no chance of partners being trying to coexist once again. When those grounds are not there at all, when they've settled, for example, the alimony, the children's issues and everything else, then definitely the 6-month mandatory period can be done away with, and under Article 142 of the Constitution, the Supreme Court can do away with it. So that's the ground, and that's the ruling that they've given. This will definitely come as a huge relief for those who have been waiting, where they can definitely then appeal and hopefully get some kind of relief at the earliest.
All right, for more on this, Kapil Madan, advocate in the Supreme Court, and Aashutoshsrivastava, also advocate in the Supreme Court, both joining us now to try and decode what this means for all of us, the Aam Aadmi on the ground. So first of all, Kapil Madan, to you, why is this, and if so, why is it a landmark judgment?
Yes. So, if you look at the scheme of the Act, the period of 6 months was provided under the Act as a cooling off period to give parties a chance to rethink about, breaking their marriage, dissolving their marriage. And perhaps that's the reason why you had this 6 months cooling off period, which is also known as a mandatory waiting period. So, the court has clarified that under extreme circumstances you can waive off this waiting period. And another important factor in the judgment is that the Supreme Court has also recognized irretrievable breakdown of marriage as one of the grounds to seek divorce. If you look at the Hindu Marriage Act, irretrievable breakdown of marriage is not one of the factors which can weigh with the court on the basis of which a decree of divorce can be granted in a contested case. If you look at the other jurisdiction, in America, you have irretrievable breakdown of marriage as one of the grounds to seek divorce. So, perhaps this is, finding or the decision by the court where, though the Act does not provide irretrievable breakdown of marriage as a ground for divorce, since the court has now recognized, I think, to me, this is the landmark feature of the judgment.
All right. So then, Aashutoshsrivastava, but this court seems to have also given some conditions, right? So how does one decide when a marriage will be irretrievably broken down? What are those conditions? How will it play out? Is it case by case?
See, as of now, when the couple used to file a divorce by mutual consent under Section 13B of the Hindu Marriage Act, obviously there was a waiting period of 6 months.
Yeah.
So the court used to give 6 months that you go, you decide, you come back again after 6 months.
Yes.
You see that if you have any, immediate issues by which you have come before this court for divorce, so you get sufficient opportunity to discuss the issue between both of you, and then you can come after 6 months. So that used to delay the entire process. Now, by that time, maybe the couple, they are filing different kind of cases against each other, different kind of allegations against each other, and then it used to get delayed because the matter in hand also, the Supreme Court realized that the couple had stayed only for 4 years, and they had a long battle of 25 years in the court by different litigations against each other. So the court found that, filing cases against each other is also a kind of cruelty, because there was no provision in the Hindu Marriage Act for irretrievable marriage by which you can go and get the divorce. The cruelty was only the ground. So the court has considered that these kind of litigations, when both the couples have decided not to stay together and they are just unnecessarily litigating against each other, can also be considered as the ground for cruelty, and under which the marriage can be dissolved, and both the parties can be freed by exercising such power. And while doing so, the Supreme Court has invoked Article 142 of the Constitution, which gives such powers to the Supreme Court to make such decisions based on the execution of any orders or decrees. So accordingly, it decided. And obviously, it is a landmark judgment because it will save a lot of time of the people who are not at all interested to stay together.
Got it.
And
so
it
the point
also,
here, I just want to clarify for our viewers, this is only in those cases where there is divorce by mutual consent, where both sides want it, right?
Yes.
That's the first important point. Okay, but Kapil Pradhan, if you can... Yeah.
Yes, 6 months period is as per the mutual consent only. That 6 months, a waiver of these 6 months. Whenever somebody goes and files a petition under 13B of the Hindu Marriage Act, then there was a waiting period of 6 months.
Yeah. So you're clarifying that waiting period was always in place anyway, only for mutual consent divorce, not contested divorce, etc., etc. But Mr. Madan, again, I just want to look at those conditions or the criteria, because if I can play devil's advocate, there was a logic to having the 6-month waiting period in place, right? Like it was, I think it was called a cooling off period, that you may change your mind. Of course, criticism of it was that, women were told, no, you have to wait for 6 months. You're not treating them as adults who can take decisions. But there was a logic for which that was put into place. So what happens to that, or the merit of that argument, which has held on the ground for so many years?
See, we need to, look at this on case-to-case basis. There could be, cases where the parties who are litigating, they may have issues, they may have children. So, I mean, the court, while deciding the waiver application, they look at the, facts and circumstances of that particular case, and then they pass an order accordingly. I just quote another, example from the Act. The Act also provides that within first year of marriage, there cannot be a divorce petition for divorce by mutual consent. There is a bar. However, there is an exception to this rule, wherein you can, go to the court, file an application and seek waiver of this condition. However, the court are very conservative while allowing such an application. So I think it's a, to my understanding, it's a step in the, right direction, because once the parties, all the parties who are litigating these kind of cases, they are adults, they know what are their life circumstances.
Yeah.
And this, unnecessarily increase the workload on the court, because it's technically it's the same thing that happens while one moves a second petition. There is nothing new. What happens once a couple goes before the court and present their first motion petition seeking divorce, there is nothing that a judge or the court does when a second motion petition is presented. So it's merely a procedural requirement wherein the parties had to wait for 6 months. and they have to appear before the same court with the same set of petition, with the same set of facts. Now, the point is, when the parties are clear, their mindset is clear, and when they have taken the decision, and mind you, when the petition is presented in the court, the judge inquires about the facts that are stated in the petition, whether those facts are correct, whether the information that is given is correct, whether the date of marriage is correct, whether the date of separation is correct or not. So all these things, the court examines when you present the first petition, which is called as a first motion. You do the same thing after 6 months. So you unnecessarily increase the workload on the court. Also, you put a pressure, an additional requirement before the litigants to appear before the court, file the petition, engage lawyers, which is nothing but a exercise in futility.
All right, so this decision is highly praised, or it's a landmark verdict, because it's a couple no longer has to go through this agony or a delay that often leads to mental breakdowns in an individual. You can say it's a closed chapter and you can move on. But again, Aashutoshsrivastava, can you just explain to us, if either of you can, whoever would like to, just put your hand up, what are those circumstances, those conditions that the court has mentioned, I think, today in the judgment, but we don't have more clarity on what exactly, like, how do you decide whether, yes, you can get that 6-month period waived off?
Obviously that when the order comes and it is uploaded, it will be there in the hands of most of the lawyers who can go through the minute details of that order. But as already having said that, this was a very old law. The Hindu Marriage Act was of 1956. Obviously, there were certain amendments in between. So the purpose of this, condition of 6 months was to basically safeguard the marriage. To promote that there should not be, dissolution of marriage. To respect the institution of marriage, so that it is not broken so easily. But now, as the times have changed, the litigations are going for years and years, then the basic purpose of getting divorced is, defeated. If somebody has to go for years together to get a divorce, so that person cannot, either it's a male or female, cannot decide the future, if they have anything in their mind. So by the time it is decided, it becomes too late for them to take further decision in their life for second marriage or maybe settlement in their lives. So I think this will safeguard the interest of the people. Rather, earlier the divorce was not so common, but now it has become a common phenomena between the couples, and they are also not dependent on each other. Both are independent, walking in most of the cases we have seen. So I think it will save the time, energy, and everything for both of them, and it will be easier for them that they sit together, and if they are not happy, they decide mutually that it's better that let's part the ways, instead of going and through a lot of litigations and years of arguments in different courts. I think this will favor different, it will give a different message, which will be in the interest of the people.
It is an order that is reflective of the times that we live in. Thank you. Sorry, go ahead, Kapil Madan. You want to quickly add something?
Yeah, I just want to. I just want to add a example, practical example. Now, sometimes what happens is that the couples are staying abroad. They came here for marriage, and there is an irretrievable breakdown of marriage. So what happens is that if you don't waive off this cooling period, then the person has to leave his employment, come here. So you have many instances like this, where it makes no sense for the court to insist that we should wait for a period of 6 months, and you should come back again after 6 months and present the same petition and present the same set of facts. So I mean, there could be numerous such situations where the parties are facing that kind of peculiar circumstances, and it is only just and proper in those cases to waive off these mandatory 6 months period.
All right. So again, it's reflective of the times we live in. It's just making things more practical. It's aware of the fact, as you say, there could be people who've been married here, living abroad. You'd have to come back here in order to get your divorce through. Thanks, both of you, for clarifying all of that and simplifying this order for our viewers. Thanks so much.